So good morning to all of you. I hope all of you are doing great. So let's start today's discussion. Today we are planning to discuss 2018 shift 1 and some of the questions from shift 2 as well. Today we are going to discuss CRPC, that is Criminal Procedure Code. Then we are going to discuss Negotiable Instrument Act. Then moving further, we are going to discuss about Constitution of India. And if you people haven't subscribed to our channel, please go and subscribe to the channel and press the bell icon so that whenever me or any of the faculty members are coming live, you will get the notification. And don't forget to hit the like button for the videos, right? And do check it out. Link is in the description box for MP Civil Judge Prelims. That is very much important for you. It is going to provide you extra fetch of 5 to 10 marks by these 10 plus mocks, one-on-one doubt clearing and mentoring session, recorded video lectures, and much more. Right. So let's start today's discussion. Question number 91. Question number 91, what it is saying: under what section of Criminal Procedure Code a magistrate may direct local investigation? This is a purely section based question. So what they are asking, under what section of Criminal Procedure Code a magistrate may direct local investigation? Your options are: option A, section 133, option B, section 145, option C, section 147, and option D, section 139. I'm repeating the options again. Option A, section 133, option B, section 145, option C, section 147, and option D, that is section 139. So what should be the correct answer of this question? Yes, its correct answer will be D for Delhi, that is section 139. So section 139 is talking about your local investigation, while section 147 is talking about local inquiry. So remember, here you have to read this word very much clearly: local inquiry or investigation. No, Viniji, it 91 ka correct answer will not be B, it will be D. Question number 92. Under Criminal Procedure Code, how much punishment may be awarded to an accused who is found guilty under a summary trial? So I'm repeating the question again. How much punishment may be awarded to an accused who is found guilty under a summary trial? Your options are: option A, not exceeding 3 months, option B, not exceeding 6 months, option C, not exceeding 1 year, and option D, not exceeding 2 years. So in the cases of summary trial, if you have read section 263, 264, 265, you will be having a good idea that under summary trial, how much maximum punishment may be awarded to the accused. Your options are 3 months, 6 months, 1 year, and 2 year. What should be the correct answer? Yes. Yes, its correct answer is A, that is not exceeding 3 months. Not exceeding 3 months, right? Next question, question number 93. A confessional statement recorded under section 164 of Criminal Procedure Code. A confessional statement under section 164 of CRPC can be recorded. Option A, during the course of investigation only and not afterwards. Option B, during the course of investigation at any time afterwards of commencement of trial with the permission of court. Option C, during investigation as well as during inquiry but before the commencement of trial. And D, during investigation, inquiry, and trial. What should be the correct answer? Question number 93. Yes. Question number 93. What should be the correct answer? Now, before you people answer this particular question, let me tell you this particular question has been deleted by MP High Court, right? There was some dispute with this question, the language of this question. Ideally, its answer should be A for Ahmedabad, that is during the course of investigation only and not afterwards, right? But Supreme Court of India in some of the other cases held that the statement, a confessional statement, can be recorded during inquiry also in some cases along with investigation. So its possible answer can be C as well. Question number 94. CRPC, Criminal Procedure Code, in Madhya Pradesh, offense under section 363 of Indian Penal Code. Section 363 of IPC is liable by which court? Your options are: A, Judicial Magistrate of First Class, option B, Chief Judicial Magistrate, option C, Court of Session, and option D, Chief Metropolitan Magistrate. What should be the correct answer? under CRPC in MP, offences under section 363 of IPC is liable by which court? Judicial Magistrate of First Class, Chief Judicial Magistrate, Court of Session, and Chief Metropolitan Magistrate. What should be the correct answer? 94. Yes. Judicial Magistrate of First Class, Chief Judicial Magistrate, Court of Session, and Chief Metropolitan Magistrate. So its correct answer will be your C for Calcutta, that is Court of Session, right? Next question, question number 95. Under CRPC, if an offence under section 376 of IPC is committed, the information shall be recorded by a women police officer. Under which section? So which particular section states that if an offence of rape under section 376 of IPC is committed, the information has to be recorded by a women police officer? Your options are section 154, section 155, section 156, and section 157. 154, 155, 156, and 157. What should be the correct answer? 95. Yes, 95A is the correct answer. That is section 154, right? Section 154 talks about information as to cognizable offenses. Now, question number 96. The magistrate of first class may pass a sentence. Magistrate of first class may pass a sentence. Option A, imprisonment for a term not exceeding 2 years or fine not exceeding 5,000 rupees or both. Option B, imprisonment for a term not exceeding 1 year and fine not exceeding 5,000 rupees or both. Option C, imprisonment not exceeding 3 years or fine not exceeding rupees 10,000 or both. Option D, imprisonment for a term not exceeding 7 years or a limited fine or both. So what should be the correct answer? Question number 96. Yes. Can anyone tell me what should be the correct answer of question number 96? They are simply asking the power of magistrate of first class to pass a sentence. Yes, Viniji, you are correct. C is the correct answer for this question. That is imprisonment not exceeding 3 years or fine not exceeding rupees 10,000 or both. Question number 97. Under Criminal Procedure Code, imprisonment in default of payment of fine can be awarded. CRPC, imprisonment in default of payment of fine can be awarded. Option A, to run concurrently with substantive sentence imposed. Option B, in addition to substantive sentence imposed. Option C, court can condone it. And option D, none of these or none of the above. So imprisonment in default of payment of fine can be awarded. Option A, to run concurrently with substantive sentence imposed. Option B, in addition to substantive sentence imposed. Option C, can condone it. And D, none of these. So question number 97, what should be the correct answer? Yes, its correct answer is B for Bangalore. That is in addition to substantive sentence imposed. Question number 98, procedure of arrest and duties of officer making an arrest is provided under section dash of CRPC. Procedure of arrest and duties of officer making arrest is provided in section dash of CRPC. Your options are 41B. Option A is saying 41B. Option B is saying 41A. Option C is saying 41D. And option D is saying 41C. What should be the correct answer? Yes. Duties of the police officer while making an arrest. What are the duties? He should have ABC, that is accurate, visible, and clear identity. He should bear accurate, visible, and clear identity. This is contained in which section? So correct answer is A for Ahmedabad, that is section 41B. No, Viniji, 97 you are saying B. Yes, 97 ka B is the correct answer. 98 A is the correct answer, right? Question number 99. CRPC, Criminal Procedure Code. Court may alter charges. Court may alter charges. Option A, only before evidence of prosecution is closed. Option B, only appellate court may alter charges. Option C, charges cannot be altered in any circumstances. Option D, at any time before judgment is pronounced. So alteration of charges, if you will read section 216 of your Criminal Procedure Code 1973, you will be knowing that the court may alter the charges at what time. So what should be the correct answer? Yes. Court may alter charges only before evidence of the prosecution is closed. Only appellate court may alter the charges. Charges cannot be altered, and option D, at any time before the judgment is pronounced. So its correct answer is D for Delhi. Yes, Ankita Gupta ji, you are correct. 99, D is the correct answer. Question number 100. Executive magistrate may require security for good behavior from habitual offender under section dash of Criminal Procedure Code. Now, let me tell you, they are asking executive magistrate may require security for good behavior from habitual offender, and the security taken by the executive magistrate under this particular section can be up to 3 years. So what should be the section number under which executive magistrate may ask for the security? Your options are option A, section 109, option B, section 110, option C, section 106, and option D, section 108. What should be the correct answer? 109, 110, 106, and 108. What should be the correct answer? Question number 100. Yes. Yes, 100 ka B is the correct answer. Ankita ji, you are correct. Vinny ji, you are also correct. Now, let's move further. Question number 101. Criminal Procedure Code. Magistrate may take cognizance of an offence on complaint if in his opinion. Magistrate may take cognizance of an offence on complaint if in his opinion. Option A, there is sufficient ground for conviction. Option B, there is prima facie no probable defense of the accused. Option C, accused is not innocent. Option D, there is sufficient ground for proceeding. Now, if you will read section 200, that is complaint to the magistrate, in that it is simply mentioned. It is simply mentioned that magistrate may take cognizance of an offence on complaint if in his opinion. So the option will be D for Delhi, that there are sufficient ground for proceeding. If there are sufficient ground for proceeding, then in that case, magistrate may take cognizance of an offence on complaint. Yes, Vinny ji, you are correct. 101, D is the correct answer. 102. Definition of victim is defined under section dash of CRPC. The definition of victim is given under which section of CRPC? Option A, section 2WA. Option B, section 2U. Option C, section 2D. And option D, section 2V. 2WA, 2U, 2D, and 2V. Yes. What should be the correct answer? 102. Definition of victim is given under which section of CRPC? 2WA, 2U, 2D, 2V. So its correct answer will be your option A for Ahmedabad, that is section 2WA. Remember that under section 2U, the definition of public prosecutor is given. Under section 2D, the definition of complaint is given, right? Question number 103. Yes, Ankita Gupta ji, you are correct. 102A is the correct answer. 103. Under provision of section 372 of Criminal Procedure Code, victim has no right to prefer an appeal against any order passed by the court. Under proviso to section 372 of CRPC, victim has no right to prefer an appeal against any order passed by a court. Option A, acquitting the accused. Option B, convicting for a lesser sentence. Option C, imposing inadequate compensation. And option D, imposing inadequate sentence. What should be the correct answer? Question number 103. Under section 372 of CRPC, victim cannot prefer an appeal in which of the following cases? So its correct answer will be D for Delhi, that is imposing inadequate sentence. But while in other cases like acquitting the accused, convicting the accused for lesser offense, or imposing inadequate compensation, in all these cases appeal can be made. But under the option D, that is imposing inadequate sentence, appeal cannot be made. Yes, Vinny ji, you are right. Question number 104. The period of limitation for taking cognizance of any offence shall be 3 years. In which of the following cases we can say that the period of limitation for taking cognizance of any offence shall be 3 years? If you have read section 468 of your CRPC, you will be having idea. Question number 104. The period of limitation for taking cognizance of an offence shall be 3 years. Option A, if the offence is punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years. Option B, if the offence is punishable with imprisonment for a term exceeding 3 years but not exceeding 7 years. Option C, if the offence is punishable with the imprisonment for a term exceeding 1 year but not exceeding 10 years. And option D, if the offence is punishable with the imprisonment not exceeding 1 year. Question number 104. What should be the correct answer? Question number 104. The period of limitation for taking cognizance of any offence shall be 3 years. In the cases where the offence is punishable with exceeding 1 year and not exceeding 3 years. So it's A is the correct answer. A for Ahmedabad is the correct answer. Yes. Question number 105. When the person who would otherwise be competent to compound an offence under section 320 of CRPC is dead, then option A, legal representative of such person as defined in the Code of Criminal Procedure 1973 can compound the offence with the permission of the court. Option B, offence can be compounded by any alive eyewitness. Option C, offence cannot be compounded after the death of the person. And option D, legal representative of such person as defined in the Code of Civil Procedure 1908 can compound the offence with the consent of the court. Ankita Gupta ji, yes, 104 ka A is the correct answer. Vinny ji, it will not be B, it will be A, right? Now, question number 105, again related with section 320 of CRPC. So what should be the correct answer? Who can compound the offence with the prior permission of court if the party to the suit, that is like the complainant, is dead? Then in that case, who can compound the offence? 105, again it will be D, not A. I was very much sure कि आप में से कुछ लोग ये गलती जरूर करेंगे. Here what you have to remember is this particular word, right? This particular word. Remember that the legal representative definition is not given under CRPC. It is given under CPC. So its correct answer will be D for Delhi, right? Now, next question, question number 106. This is your first question. Yes, Ankita ji, you are correct. Question number 106. This is the first question from Negotiable Instrument Act. Which of the following section of Negotiable Instrument Act is related with presumption? Which of the following section of Negotiable Instrument Act is related with presumption? Option A, section 119. Option B, section 137. Option C, section 139. And option D, all of these or all of the above. So what should be the correct answer? The presumption as to relating, like which of the following section deals with the term presumption? Section 119, 137, 139 and all of these or all of the above. What should be the correct answer? Question number 106. Yes, just let me know what should be the correct answer. Its correct answer will be D for Delhi, that is all of these. Now, there is a very good news for all of you. Delhi Judicial Services came up with the vacancy. Delhi Judicial Services came up with 123 vacancies, if I'm not wrong, or something like that. For general, there are 86 vacancies. Today only they have notified. For higher judicial services, there are 32 vacancies in general. And for lower judicial services, 85 vacancies. That is a great number. Looking into the state like Delhi, 85 vacancies in general, right? So just do check it out. Don't forget to fill the form, right? Question number 107, right? Negotiable Instrument Act. Whether a minor may draw, endorse, deliver and negotiate any instrument. Question number 107. Whether a minor may draw, endorse, deliver and negotiate any instrument. Option A, only when he can understand the consequences of it. Option B, only when it is beneficial for them. Option C, only when it is made with the mutual consent of both of the parties. And option D, yes, he may do so as to binding all the parties except himself. So, what should be the correct answer of question number 107? Yes, he may do so as it is binding on all the parties except himself. So 107, correct answer will be D for Delhi, right? Good. Chaliye. Question number 108. That is again from Negotiable Instrument Act. When the cause of action accrues, if the check issued by the drawer is dishonor. So they are simply asking when the cause of action arises in the cases of dishonor of check. Now, option A, on the date receipt of the information by the bank regarding the return of check as unpaid. Option B, on the date when the notice is issued by the payee to the drawer. Option C, on the date drawer of the check fails to make payment of check amount to payee within 15 days from the date of receipt of demand notice. Option D, none of these or none of the above. So question number 108, what should be the correct answer? Yes, just let me know quickly. Question number 108, what should be the correct answer? When the cause of action arises in the cases of dishonor of check. When the cause of action arises in the cases of dishonor of check. What should be the correct answer? Yes. Just let me know. Question number 108. Its correct answer is C for Calcutta. That is, on the date drawer of the check fails to make the payment of check amount to pay within 15 days from the date of receipt of check. Question number 109. No, Viniji, its correct answer will be C, not D. Question number 109. Supreme Court has laid down certain directions to criminal courts for speedy and expeditious disposal of cases falling under section 138, that is dishonor of check, under Negotiable Instrument Act 1881, in the famous case of option A, Indian Bank Association and others versus Union of India. Option B, Rangappa versus Mohan. Option C, Associated Cement Company Limited versus Kesarivanand. Option D, K. Bhaskaran versus S.V. Balan. K. Bhaskaran versus S.B. Balan. What should be the correct answer? This is case law related question. Question number 109. So its correct answer is your option A, that is Indian Bank Association and others versus Union of India. Right? Next question. Question number 110. And the last question from the law section of MP Civil Judge 2018 shift 1 question paper, right? So question number 110. In a recent case, Supreme Court has held that where the check amount with interest and cost as assessed by the court is paid by a specified date, the court is entitled to close the proceeding in exercise of its power under section 143 of the Act, read with section 258 of CRPC, that the case is option A, Messrs. Meters and Instruments Private Limited and others versus Kanchan Mehta. Option B, K.M. Ibrahim versus K.P. Muhammad and others. Option C, Damodar S. Prabhu versus Sayyid Baba Lal H. Option D, MP State Legal Service Authority versus Pratik Jain. Question number 109. Yes, Ankita Gupta ji, you are correct. A was the correct answer. Question number 110. What should be the correct answer? Question number 110. Messrs. Meters and Instruments Private Limited and others versus Kanchan Mehta. K.M. Ibrahim versus K.P. Muhammad and others. Damodar S. Prabhu versus Sayyid Babalal. MP State Legal Service Authority versus Pratik Jain. So question number 110, its correct answer is A. That is Messrs. Meters and Instruments Private Limited and others versus Kanchan Mehta. Now we are going to discuss 2018 MP Civil Judge Prelims Entry Level Exam Shift 2 question paper. So Shift 2 question paper, first question was from Constitution of India. What they are stating in this question, which of the following writs can be issued against public as well as private authority? So which of the following writ can be issued against public as well as private authority? Your options are option 1 habeas, like there are certain codes. Code 1 is habeas corpus, code 2 is mandamus, code 3 is prohibition. Select the correct answer given above. Option A, first, only first follow, only second follow. C, first and third follow. D, second and third follow. They are asking which of the following writ can be issued against private individual as well as against public authority. Habeas corpus, mandamus, prohibition. So what should be the correct answer? First, second, first and third, second and third. What should be the correct answer of question number 1? Yes, they are talking about writ. So its correct answer will be A, that is the writ of habeas corpus. The writ of habeas corpus can be issued against private individual as well as against public authority. No, it will not be B. Remember, writ of mandamus can be issued only against public authority, right? Not against private individual. But the writ of habeas corpus can be issued against private individual as well as against public authority. Question number 2. The state shall provide free and compulsory education to all the children. The age of 6 to 14 years is enshrined in the article. Option A, Article 21. Option B, Article 21A. Option C, Article 25. And option D, Article 30. So, the state shall provide free and compulsory education to all the children at the age of 6 to 14 years. This particular idea is enshrined in which article? Option A, Article 21. Option B, Article 21A. Option C, Article 25. And option D, Article 30. What should be the correct answer? Right to free education. Right to free education. This particular idea is enshrined under which article? So its correct answer will be B for Bangalore. That is under Article 21A. Right? Right. Viniji, you are correct. Its answer will be 21A. Question number 3. In which of the following amendments, yes, Ankita Gupta ji, you are also correct. In which of the following amendments of Constitution made in mandatory for the President to accept the advice given by Council of Ministers? So in which case it has been mandated that the advice given by the Council of Ministers has to be accepted by the President. Your options are option A, 39th Amendment, option B, 42nd Amendment, option C, 49th Amendment, and option D, 44th Amendment. So what should be the correct answer? President has to follow the advice of Council of Ministers. This particular idea was stated in which of the following amendment? What should be the correct answer? Yes. So its correct answer is option B, that is 42nd Amendment. Under 42nd Amendment, this idea was inculcated, right? Next question, question number 4. An ordinance can be issued by the President at any time when? An ordinance can be issued by the President at any time when? Option A, Parliament is in session. Option B, Lok Sabha is not in session. Option C, Rajya Sabha is not in session. Option D, both the houses of Parliament are not in session. So what should be the correct answer? When Lok Sabha is in session, when Parliament is in session, Lok Sabha is not in session, Rajya Sabha is not in session. Both of the houses of Parliament are not in session. Question number 4. Ordinance, when ordinance can be issued by the President? So its correct answer will be D. When both of the houses of Parliament are not in session, and at that time, President can issue an ordinance, and that ordinance shall remain valid only for the period of 6 months. Right? Right. चलिए आगे बढ़ते हैं. अंकिता जी, विनी जी, both of you are correct. Question number 5. Article of Constitution of India relates to Uniform Civil Code. Which article of Constitution of India relates to Uniform Civil Code for citizens? Option A, Article 45. Option B, Article 44. Option C, Article 48A. Option D, Article 43A. What should be the correct answer? Uniform Civil Codes for the citizens. This particular article is defined under which article number? Under the chapter of Directive Principle of State Policy, chapter 4. Article 45, 44, 48A and 43A. Its correct answer is Article 44. Yes, Ujjwal Nahar ji, you are also correct. Ankita Gupta ji, Vinny ji, both of you are correct with in reference with question number 5. Question number 6. Decision of the Supreme Court relating to ban on smoking at public place is. Decision of the Supreme Court relating to ban on smoking at public place is option A. So Murli S. Deora versus Union of India. Option B. Yes, Ujjwal Naharji, with fifth question, you are also correct. Question number 6. Decision of Supreme Court relating to ban of smoking at a public place was option A. Murli S. Deora versus Union of India. Option B. Food Corporation of India versus Bharatiya खाद्य निगम कर्मचारी संघ. Option C. Javed versus State of Haryana. Option D. S.R. Chaudhary versus State of Punjab. So its correct answer is C, sixth ka A. Murli S. Deora versus Union of India. Yes, Vinny ji, you are correct. Question number 7. The Constitution of India, where a law is made by the state legislature on the subject enumerated in the concurrent list with the assent of the president, repugnant to the earlier law made by the parliament, then the law made by the state, option A, shall prevail in the state, option B, shall not prevail in the state, option C, shall prevail in the state with the permission of Supreme Court, option D, shall prevail in the state with the permission of High Court. So this particular question is related to your 7th schedule as well as your article 245, 246, 247, वहां से भी ये question derived है. So what should be the correct answer? When a particular law made by the state legislature on the subject matter which is in concurrent list, and the law made by the state government or state legislature is against the law made by the parliament, but the law made by the state government has got the assent of President of India, then that particular law shall prevail in the state. So 7th ka A is the correct answer, right? Yes, Vinny ji, you are correct. Now, according to the Constitution of India, the term district judge shall not include. According to Constitution of India, the term district judge. Yes, Ankita Gupta ji, you are also correct. 7th ka A is the correct answer. Question number 8. According to Constitution of India, the term district judge shall not include. Option A, Chief Presidency Magistrate. Option B, Sessions Judge. Option C, Chief Judicial Magistrate. Option D, Chief Judge of Small Cause Court. So which of the following person is not included in the term district judge under the Constitution of India? Chief Presidency Magistrate, Sessions Judge, Chief Judicial Magistrate. Option D, Chief Judge of Small Cause Court. What should be the correct answer? Yes, 8th ka correct answer will be C, that is Chief Judicial Magistrate. So Chief Judicial Magistrate is not included in the term district judge, right? Under Constitution of India. 8th ka, yes, C is the correct answer. Now, Vinny ji, you are correct. Question number 9. Article 24 of Constitution of India prohibits the employment of children in any factory or mine or in any hazardous employment below the age of option A, 18 years, option B, 12 years, option C, 14 years, option D, 16 years. So under Article 24, yes, Ankita Gupta ji, you are saying 8th ka A. It will not be A, it will be C. Under Article 24, below which age child cannot be involved in any hazardous industry, factory or mine. 18 years, 12 years, 14 years and 16 years. So its answer will be C. Yes, 9th ka C is the correct answer, Ankita ji, that is below the age of 14 years. Question number 10, that is the power to grant pardon, reprieves, respites or remissions of punishment, etc. under Article 72 of Constitution is exercised by the President of India. Option A, on the advice of the Prime Minister. Option B, on his own as the head of the Union. Option C, on the advice of Council of Ministers. And option D, on the advice of Law Ministers. So what should be the correct answer? The President exercises the power of granting pardon, reprieve, respite, remission under Article 72 on the advice of Prime Minister, on his own as a head of the union, option C, on the advice of council of ministers, and option D, on the advice of law minister. What should be the correct answer? Question number 10. Yes. What should be the correct answer? Question number 10. Just let me know quickly. Yes, its correct answer will be C for Calcutta. C for Calcutta, right? So he exercised the power on the advice of Council of Ministers, right? Chaliye. So we are going to stop here for the day. Don't forget to check out जो लोग भी दिल्ली पे फोकस कर रहे थे, काफी लंबे समय से दिल्ली की कोई वैकेंसी नहीं आई थी, तो राइट नाउ 85 वैकेंसीज इन जनरल इज आउट इन दिल्ली जुडिशियल सर्विसेज. ठीक है, 2019 के बाद से कोई एग्जाम नहीं हुआ था. 2021 और 22 तीनों की मिला के 85 वैकेंसीज आई हैं, विच इज अ वेरी गुड नंबर looking into a state like Delhi. So get set ready for exam. Most probably they are going to conduct the exam in the month of June or July. So and probably there are chances उसके पहले भी हो सकता है exam Delhi Judicial Services का. So get ready for that, right? And we are definitely going to come up with the past year question papers discussion of Delhi Judicial Services as well, right? As of now, if you people like enjoying the sessions which we are taking, don't forget to like, because we make lot of effort, like the research team and including me, all of us makes lots and lots of efforts to come up with such a concise MCQs, past year question papers for your preparation. So don't forget to press the like button and hit the subscribe button. And if you people haven't checked out MP Civil Judge Prelims Crash Course, link is in the description box. Do check it out. Thank you, Ankita Gupta ji. Thanks to all of you. See you people tomorrow, right? With some new discussions. चलिए, take care. Bye bye. मिलते हैं अगली क्लास में कुछ और नई डिस्कशंस के साथ.